Roman law, developed over a millennium from the early Republic through the Empire, has left a profound and enduring legacy in European legal systems. Its influence extends far beyond the fall of Rome in 476 CE, shaping not only legal institutions, but also the broader philosophical understanding of law, justice, and governance in Europe. Understanding this legacy involves examining Roman law's structure, its codification, its revival during the Middle Ages, and its incorporation into modern European legal traditions. 1. Structure and principles of Roman law. Roman law was highly sophisticated, encompassing civil law, jus civile, the law of the people, law of nations, jus gentium, the law governing interactions with foreigners, and natural law, jus naturale, reflecting universal principles of justice. At the core of Roman legal thought was the distinction between private and public law, as well as procedural rigor in judicial processes. The 12 Tables, 451 to 450 BCE, laid the foundation for codified law, emphasizing transparency and predictability. Later, jurists like Gaius, Ulpian, and Papinian contributed extensive commentaries and treatises that articulated concepts such as contracts, stipulation, property rights, dominium, obligations, delicts, torts, and succession, which became central pillars for European civil law. One of the most significant contributions of Roman law is its notion of equity, equitas. This principle allowed judges and magistrates to interpret laws flexibly, balancing strict legal rules with fairness and moral reasoning. The concept of equity would later profoundly influence medieval and modern European law, providing the philosophical groundwork for balancing rigid codification with justice in individual cases. 2. Roman legal codification and the Corpus Juris Civilis. The apex of Roman legal codification came under Emperor Justinian I in the 6th century CE with the creation of the Corpus Juris Civilis, body of civil law, comprising the Codex Justinianus, the Digest, Pandects, the Institutes, and later the Novellae. The Corpus Juris Civilis systematically organized centuries of legislation, senatorial decrees, and juristic writings, preserving Roman legal thought for posterity. Its clarity, structure, and comprehensive coverage of civil, criminal, and procedural law made it an invaluable resource for later generations. Although the Western Roman Empire had fallen by Justinian's time, the Corpus Juris Civilis remained a central reference in the Eastern Roman Byzantine Empire. Its reintroduction to Western Europe around the 11th century, particularly in Italy, triggered a revival of Roman law studies, influencing medieval universities and legal practice. 3. Reception of Roman law in medieval Europe. The revival of Roman law in Europe, known as the Reception, occurred mainly during the 11th to 13th centuries. Scholars in Bologna, particularly Irnerius and his disciples, began teaching Justinian's texts, interpreting them to apply to contemporary legal issues. Roman law provided a model of rationality and coherence that medieval European rulers found useful for consolidating power and standardizing legal procedures. The reception of Roman law had different regional impacts. In the Holy Roman Empire, it coexisted with local customary law, gradually harmonizing fragmented legal practices. In Italy, Spain, and the Netherlands, Roman law principles formed the backbone of civil codes. France, while initially resistant to Roman legal dominance due to strong customary traditions, eventually incorporated Roman principles into legal thought, influencing the later Napoleonic Code. In Eastern Europe, particularly in Poland and Hungary, Roman law concepts were integrated into local statutes and canon law, bridging secular and ecclesiastical jurisdictions. 4. Roman law and canon law. The influence of Roman law extended into the ecclesiastical sphere. The Church adopted Roman legal concepts to structure canon law, particularly in regulating marriage, inheritance, contracts, and criminal offenses under ecclesiastical courts. Gratian's Decretum, 12th century, reflects the synthesis of Roman legal principles with Christian moral norms, creating a legal system that governed not only spiritual matters but also social and familial relations in medieval Europe. The Church's legal apparatus helped preserve Roman law's analytical methods and terminology throughout the Middle Ages, ensuring continuity in European legal culture. 5. Roman law as the basis for modern civil law systems. Modern European civil law systems, often called continental law, owe much to Roman law. Countries like France, Germany, Italy, Spain, Portugal, and the Netherlands built their legal codes on Roman legal principles, particularly during the codification movements of the 18th and 19th centuries. Key areas influenced include contract law, concepts of consent, obligations, and remedies derived directly from Roman law doctrines. Property law, ownership, servitudes, and possession rules mirror Roman jurisprudence. Family law, marriage, inheritance, and guardianship regulations reflect Roman structures. Delict, tort law, liability, and compensation principles trace back to Roman legal analysis. The Napoleonic Code, 1804, exemplifies this influence, combining Roman legal rationality with revolutionary ideals. Germany's Bürgerliches Gesetzbuch, 1900, similarly integrates Roman legal methodology, emphasizing systematic codification and clarity. 6. Influence on legal education and profession. Roman law has shaped European legal education. For centuries, law students studied Justinian's compilations, learning legal reasoning and doctrinal analysis. The emphasis on systematic thinking, legal interpretation, and jurisprudential reasoning continues to underpin legal curricula in many European countries. Roman law also influenced the professionalization of the legal profession, establishing the role of jurists, notaries, and judges as interpreters and guardians of codified law. 7. Philosophical and conceptual legacy. Beyond technical rules, Roman law left an enduring conceptual legacy. Ideas such as natural law, justice as fairness, equality before the law, and the public-private law distinction underpin European legal philosophy. Thinkers like Thomas Aquinas, Hugo Grotius, and Samuel Pufendorf drew on Roman law and its natural law principles to develop theories of international law, human rights, and state authority. Even today, debates on European Union law and constitutional principles often reflect Roman legal concepts. 8. Limitations and regional variations. While Roman law had widespread influence, its impact was not uniform. Northern Europe, particularly England, largely retained common law traditions, which developed through custom, judicial precedent, and parliamentary statutes rather than Roman codification. However, even in England, Roman legal ideas filtered into equity and academic discourse, showing that Roman law's conceptual reach extended beyond codified systems. Conclusion. The legacy of Roman law in Europe is profound and multifaceted. From its codification in the Corpus Juris Civilis to its medieval revival, its integration with canon law, and its foundational role in modern civil law systems, Roman legal thought continues to shape European jurisprudence. Its principles, equity, codification, rationality, and systematic analysis remain central to understanding law's function in society. Roman law is more than historical artifact. It is a living intellectual tradition that continues to influence legal practice, education, and theory throughout Europe. Sources 1. Watson A., 1995. The Spirit of Roman Law, University of Georgia Press. 2. Golowich H.F. and Nicholas B., 1972. Historical Introduction to the Study of Roman Law, Cambridge University Press. 3. Stein P., 1999. Roman Law and European History, Cambridge University Press. 4. Zimmerman R., 1996. The Law of Obligations, Roman Foundations of the Civilian Tradition, Oxford University Press. 5. Berman, H.J., 1983. Law and Revolution, The Formation of the Western Legal Tradition, Harvard University Press. 6. Kelly J.M., 2006. A Short History of Western Legal Theory,